Hi, everybody. It's Laura Frederick from How to Contract, and I'm here to talk about why we do NDAs and why it's important that you understand why we do NDAs. Those were the first contracts that many of us did on a regular basis. NDAs seem to be the training wheels of contracts. They seem to be the apprentice program managers or partners give to newer people working with contracts so that they can learn the ins and outs. Now, if your experience was like mine, it was rough. I started working on NDAs and had no idea what I was doing. And the partner would say, mark up whatever is unusual. What do I know it's usual? I just started looking at these. Or take into account the deal and just mark it up so it makes sense. What does that mean? So we'd often get these vague instructions and we'd be left to figure it out and we'd take a stab at it based on our best guess. And often when I turn in that draft of my NDAs in those early days, the partner would basically reject almost everything I did and redo it in a different way. And over time, I figured out the kinds of things he changed, the kinds of things he pushed back on, the kinds of things he did. And eventually I understood more about the practice of doing NDAs. But that didn't really help me with the fundamental problem, which was I didn't really understand NDAs in the big picture. I just knew they were something you were supposed to do. And I think this lack of understanding is pretty common. We did a survey last week asking people what were their top two questions about NDAs. And this fundamental question of why do we do NDAs was one of the most common questions asked. I wanted to make this video to share with you why I do them and why you should know that. Now, I come from a long background, 25 plus years of doing contracts where we buy, sell, and license. So my discussion of why we do NDAs is tied to that world of commercial contracts. And what I want to tell you, if you are a little bit confused about the why of NDAs, is you're not alone. It's a very common question. I'm going to go through in detail the reasoning behind NDAs. And as part of that, I'm going to be explaining when you do NDAs and when you don't, why they're important, how to discuss why they're important with other parties, and the way they fit into the bigger picture of doing your transactions. So let's kick off. Okay. So why do we do NDAs? The reason we do NDAs is because of the nature of legal protections of information. Now, if you never do an NDA and you are discussing things with your counterparty, they are not under an obligation to keep that to themselves. In a world without those agreements, any insight into another party's confidential information, trade secrets, could result in them not only using it themselves to compete with you, but freely disclosing it to the whole world. Now, if we lived in such a world, our businesses couldn't do deals because we don't know whether, in a lot of cases, we want to do a deal until we find out more about the product, about the service, about what we're getting when we enter into this transaction. Sure, we could walk into a store and buy a widget off the shelf, but in all likelihood, the manufacturer of that widget would have a hard time figuring out which supplier to use unless they could evaluate them in a way that was confidential, that these suppliers weren't going to take all this information and go use it for themselves or tell the world. So NDAs serve almost like the rules of the playground. Individual parties are agreeing that they're not going to share the other's important confidential information with the world or use it in a way that's not authorized. NDAs aren't always required. There are situations where you don't need an NDA. And what I always told my teams was you don't need an NDA if you would be comfortable with this information being on our website and being available publicly to the world. So for companies that are sharing information about their products and all that product information is already public, or It's the type that you don't really worry too much about. In those cases, you can talk about those things without an NDA. The moment that we start discussing things that I don't want to be public, that's when I want to get an NDA. NDAs have evolved into this kind of entry point for relationships. We want to keep certain parts of the discussion that we're having on this kind of preliminary basis while we figure out if we wanted to do a bigger deal. We want this information to be kept quiet and kept confidential. So we sign an NDA as soon as you are discussing things that shouldn't be public or shouldn't be used by the counterparty. That's the first level. But there's a much more important, more technical reason why it is so critical that we have NDAs in place when we're disclosing certain kinds of information. And what I'm talking about are trade secrets. When I was a newer lawyer, I thought trade secrets, confidential information, it's the same thing. I couldn't have been more wrong because confidential information is not a synonym of a trade secret. Confidential information is a plain English description and only means what you define it to mean in your NDA or your contract. Trade secret is a statutory term in most of the states. 49 of the US states have enacted something called the Trade Secrets Act. The exception is New York, which doesn't have the statute, but has adopted a lot of the same approaches through case law. All states have a trade secret law, and while they're not uniform, there is a lot of commonality. And one of the things that's common amongst them all is the definition of a trade secret. Before I get into the definition of a trade secret, I want to highlight why trade secrets matter when we're talking about NDAs. The reason it's so important is because of a consequence. If information meets the definition of a trade secret, which I'll talk about in a second, if it meets the definition of a trade secret, it's then a type of intellectual property that you can own. You can own a trade secret, and anybody who misappropriates that trade secret, misappropriates is the word we use when we're talking about essentially infringing trade secrets or improperly using and taking trade secrets. If there's a misappropriation of your trade secrets, you can sue the counterparty for damages. You can potentially pursue an injunction. There's a lot of remedies available because they would be violating your intellectual property rights in the trade secret. It's a very powerful designation. These protections and the remedies for violation that you get with a trade secret, you don't necessarily get with an NDA. These are two separate categories of protection. An NDA protects information under contract law through contract obligations. If you breach an NDA, there's a contract breach, regardless of whether there's a trade secret involved or not. With trade secrets, if somebody misappropriates or improperly uses or takes a trade secret, you have protection under the intellectual property laws, under the trade secret laws that include its own kinds of remedies and damages, including injunctive relief. These are two separate protections, but they overlay on top of each other. You may be thinking, great, two different protections, blah, 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 blah. This is why it is so critical. This is the most important reason why we do NDAs. We do NDAs not only to get that contractual protection of what is in the NDA, what is in the document. We have this understanding and relationship between the parties, but we also do it to protect our trade secrets. And the reason an NDA protects our trade secrets is because of the definition. All 50 states and most countries that have trade secret law define those trade secrets almost the same way. They have to be something that's confidential, not available to the public. It has to be something that has economic value because it's secret or not available to the public. And then finally, and this is the one to pay attention to, the owner of the trade secret has to take reasonable efforts to keep it confidential. So you could have information that is confidential and has economic value, but if you're not seen taking effective precautions to keep it confidential, you can lose the protection of your trade secret. The challenge is if your company is not signing NDAs, you may lose trade secret protection for the information that is being disclosed to counterparties without an NDA. Let me repeat that. If your company does not have NDAs in place before disclosure of certain kinds of information, there is a case that your counterparty in the future could make that the information is not a trade secret because you did not comply with the statutory requirements to take reasonable efforts to protect trade secrets. The courts have said NDAs are one of the types of reasonable efforts companies should be taking to protect their trade secrets. So you can see the potential risk. If you have regularly disclosed that information without the protection of an NDA, there's a strong case that information is no longer a trade secret and you do not have any remedies against that counterparty, at least under trade secret laws. You may still have an NDA breach, but you're not going to be able to take advantage of the trade secret protection. I don't know about your company, but every company I've ever worked for highly values their trade secrets and wants to preserve them. One of their most important assets is their intellectual property, including their trade secrets. That's why we have to have that NDA if there's any chance we're going to be sharing information with some economic value because of its secrecy. There are some counterparties where you don't need an NDA to protect your trade secrets. And typically these are counterparties who are under a separate statutory requirement to keep your information confidential. That would include banks, lawyers, and your employees. They all are covered by separate statutes. But if you are doing business with a regular counterparty that isn't covered by one of those statutes with the obligation to keep your information confidential, and you disclose this information, you have this risk. Now, one thing I want to share is the courts generally won't void your trade secret status because of a single isolated error. But if you have a pattern and practice of disclosing information without those NDAs, then that is a risk. One thing about NDAs, we do not do them to comply with data security and privacy laws. Yes, data protection laws do require keeping information confidential and restricting its use, but those are very different purposes than we have with NDAs. NDAs were created long ago, long before we had privacy and data protection laws. If you're disclosing information that you need to protect under the data security and privacy laws, my advice is you should not be doing that with an NDA. You should be protecting that kind of information to comply with privacy and data protection laws through a data processing amendment or agreement. That's proper vehicle for protecting information that's subject to data protection laws. You don't want to try and turn an NDA into a DPA, and you don't want to turn a DPA into an NDA. They're different purposes, they serve different functions. The last thing I want to say on this subject is really about what do you do with this information? Because your business teams, your sales teams, your operations teams are all resistant to the idea of NDAs. They're cookie cutter, who cares, don't worry about it. But I'm here to tell you they're right and they're wrong. On the one hand, in some transactions, NDAs really just serve the minimal purpose of protection. Let's just say you're sharing some information about upcoming production levels for your product. You don't generally have it public yet, but it's not the end of the world if it became public. That is information that you would have an NDA in place first. But if it was violated or if you lost trade secret status for that specific information, because it's going to get public very soon anyway. In those cases, NDAs are not the be all and end all. They're useful and you should have that as a practice, but sometimes it's not that critical. NDAs become very critical when you're disclosing important information that you do not want public. That would be devastating for your company if it was publicly available. It potentially could give your competitors an edge over you and have a negative impact on your company's value. Understanding why you need an NDA, why it's so important in some cases, but maybe not as important in others, will help you figure out how to spend those limited resources you have. You can't make that judgment call about which NDAs require more time and how to negotiate their terms unless you understand kind of the framework for how NDAs work and how we use them to protect our companies. When faced with these business teams who are pushing back on using an NDA, I often tell them about the trade secret rules. That potential loss of intellectual property and valuable asset of the company because of a failure to put in place an NDA. And if they say yes, oh, sure, that's fine. I don't care if our competitors have it. I don't care about any of that stuff. This isn't that important. Then you might not even need an NDA at that point if you're not disclosing that kind of important stuff yet. But if that information is important or the person who's making the disclosure does not have the authority to decide if the information is that critical or not, then that's how I help them see the importance of the NDA. Either because the information is important and we need that intellectual property protection provided by trade secret laws, or this person is not in a position to make the call to reveal that information and lose trade secret status for the company. That's the technique that works best for me. My hope with this explanation is I've helped you overcome the complexity and the overwhelm that we all feel about NDAs. Because NDAs, while they're super important, they're not impossible to understand. They're totally doable. Hopefully, this explanation has helped you understand the practical needs why you do NDAs. And I mentioned the importance of making sure that you have all the important things in your NDA and how when I started out, I really didn't understand what an NDA was supposed to have. The other thing I didn't understand were the red flags and the landmines that we should be avoiding in NDAs. My next video, I'm going to be getting into the essentials of an NDA. I want to talk to you about the 5 most important things that I look for in an NDA. Now, I'd love to get your feedback on this video, what I've been talking about, why the NDA is important, about how to talk to your coworkers and clients about the need for an NDA. If you have other insights on this topic, I'd love to hear them. We all can learn from each other about NDAs. Thanks for watching. Keep an eye out for my next video. You don't want to miss that, and I'll see you then. Bye.